Yes, good afternoon, friends. CS Manoj Mathia ji and CS Dr. S. Dhanpala ji and my dear friends. Good afternoon to all of you. Friends, Team ICSI and I being the chairman of the Practicing Company Secretary Committee under the guidance of our President CS Devender Deshpande ji are planning a lot of webinars on the recent amendments, recent recognition to we company secretaries, what topics of the day, capacity building in new area, or where we needs. Friends, recently MCA has come up with the various amendments in the LLP Act as well as rules. The view of MCA to come up with the amendments to take the LLP at global standards in order to make it more robust by cinching the same with best global practices and ease of doing business. These newly amendments bring a welcome change by all of us stakeholders. Furthering a step towards capacity building of its members, the Institute of Company Secretaries of India has come up with a series of 3 webinars in association with, jointly with, and under the guidance of Ministry of Corporate Affairs. Friends, with a view to have a detailed deliberation in these LLP amendments, what will be the implication, how we stakeholders cope with, or how we company secretary in practice or in job can come up with these amendments as required. So friends, this topic was proposed today so that the members have a grip on the subject while dealing with the LP assignments. So friends, ICSI has requested the 2 giants in this area, CS Manoj Mathia ji and CS Dhanpala ji. And both the speakers will give their views in approx 30-40 minutes, starting with CS Manoj Mathia ji. Then we will start with the question and answer sessions. A lot of questions I have received. Still, member may give their questions in the link given to in the flyer. Friends, now I will formally proceed towards introducing our speakers of the day, CS Manoj Mathia ji and CS Dhanpala ji. Both are practicing company secretary and both are reputed and both are known to everyone in the entire country. So reading the profile of both the practicing company secretary are giving a dilemma to me, but it's my formal duty to read the profile of both the speakers. CS Manoj Mathia ji is an associate member of ICSI and fellow member of ICAI. He is also the past chairman of Institute of Company Secretaries of India, EIRC. He is the managing partner of MKB and Associates and practicing since last 30 years. His core areas of practice are corporate litigation, the IBC code, appearance before the National Company Law Tribunal, NCLAT, and the regional directors. He is also involved in corporate restructuring, compounding of offenses, secretarial audit, and others. He is also a regular speaker on various subjects in the areas of corporate law, corporate restructuring, etc., conducted by ICAI and ICSI. Now I am reading the profile of CS Dr. S. Dhanpala sir. Dhanpala sir is a practicing company secretary and IBBI registered valuer and qualified lawyer at Chennai Court. Dhanpala sir is the managing partner of Mrs. S. Dhanpala and Associates, a firm of PCS since last 20 years. He has also authored many books on corporate law, NCLT, and IBC. His books is like LLP Made Easy, Handbook on Companies Act 2013, Guide to the Insolvency and Bankruptcy Code 2016 for the benefit of members. He has also addressed on various topics like corporate law, IBC, secretarial subjects on various forums. He was conferred honorary doctorate for professional excellence for thesis on governance of IBC in real estate sector from prestigious university. He was also held the position of Office of Secretary and Office of Treasurer of the SIRC of ICSI during 2015-19. Friends, now without taking much more time, I would like to request CS Manoj Mathia ji to please address us on the LLP amendment, sir. Manoj sir, please.
Thank you, Sandeep. I hope I am audible.
Yes, yes, sir.
Can I just share the screen and then start? If I may be allowed to share the screen. Is it visible, Sandeep?
Yes, sir. Yes, sir. Manoj, yes. Yes, please.
Thank you, Sandeep. My fellow speakers, Sri Dhanpala ji, and ladies and gentlemen, I thank Sandeep for inviting me as a speaker at today's webinar on limited liability partnerships, recent amendments. And I also thank him for structuring the program in such a manner that while I have to deal only with the amendments, the whole burden is on Dhanpal sir to explain what their implications are and what would be the impact of those amendments on LLPs as well as on companies. So he has the unenviable task of explaining while I have the task of stating before you what the amendments are. I must say that yes, I am very much intrigued by the LLP, the concept of LLPs, as well as the manner in which legislations have been framed in respect of LLPs. Perhaps it would be one of the very few statutes which has remained stable for almost now almost 13, 14 years with no amendments at all. While there would have been about dozens of amendments in the rules, in the act there has been no amendments at all. And even if you look at the provisions whereby the provisions of Companies Act could have been made applicable to LLPs, not much headway has been made until recently, even in respect of enforcing or adopting Section 67 of the LLP Act, by virtue of which the provisions of Companies Act could be made applicable to LLPs. I was wondering as to why even LLPs continues to even today have the references to Companies Amendment Act, Companies Act 1956, when we have Companies Act 2013 almost for 10 years now, and why no step has been taken for a rectification in this direction. I was also wondering when we have a lot of, hype on decriminalization of offences under the Companies Act, why no such similar steps were taken with respect to LLPs? 100 rupees per day was something which everybody was really bothered. And it really was very, very painful that while the actual fee would have been 300 rupees, but the additional fees which LLPs sometimes would have to pay for delayed filings of their documents resulted in 30,000 or 40,000 rupees. So there was certainly a very great need for changes to come about in LLPs. And those changes were necessitated because of change in various laws, including the Companies Act. Those changes were necessary because of the heavy burden, the existing penal provisions and the existing fee provisions of LLPs were casting on LLPs as a whole. And even this decriminalization, which was a much talked about subject as far as Companies Act is concerned, was absolutely ignored as far as LLPs were concerned. So sometime in 2019, there was a committee formed, and this committee was called as a Company Law Committee on Decriminalization of the Limited Liability Partnership Act. And though it was constituted in 2019, the committee submitted its report on 4th of January 2021. And if you look at the major recommendations which were made by this particular committee, they were with respect to decriminalization of offenses and adoption of in-house adjudication mechanism. It was with reference to adjudication of penalties, compounding of offenses. Some changes were made with respect to some of the definitions under the LLP Act. There were some changes with respect to payment of additional fees, registration offices, etc., including changes with respect to enabling provisions with respect to accounting and auditing standards. It is happy to note that majority of these recommendations have now been accepted, and they now form part of the LLP Amendment Act, which is going to be effective from 1st of April 2022. Majority of these provisions now find a place in the Amendment Act. But the Amendment Act also has certain new concepts which were not discussed by the Company Law Committee. And some of the very, very small amendments that have come in, either as a recommendation of the Company Law Committee or on its own because of regulatory and judicial pronouncements that have come in the recent past with reference to some of the issues. They are very small and subtle changes, and they need to be taken very special note of. There was a widespread fear, and there was a widespread concern as to how LLPs would raise money. Is contribution by the partners only the way of raising money in an LLP? Can an LLP raise loans? Can an LLP issue debentures? Can an LLP issue any other instrument? So all these concerns, though they were discussed by the Company Law Committee, unfortunately, even today, they don't find a place in the Amendment Act, and maybe in near future, we will have these changes also come in the LLP Act. Some of these changes. By yet another notification, they have made several provisions of the Companies Act applicable to LLPs. Section 90, provisions relating to significant beneficial owners, disqualification of directors, number of directorships, vacation of office, limited inspections. All these provisions with some suitable modifications are now being made applicable to LLPs as well. While within the given span of 30 to 40 minutes, it may not be possible for us to go through each and every change. But let me try and cover most of the important changes that have been brought in by the Limited Liability Partnership Amendment Act 2021, read with the Limited Liability Amendment Rules 2022 and certain Amendment Rules 2022. If you look at the changes that have come in the definition, a very benign looking change has come in the definition of the term business. Previously, Section 2E of the LLP Act simply defined business to include every trade, profession, service, and occupation. And now they have added a sentence which makes the definition read as follows. Business includes every trade, profession, service, and occupation, except any activity which the central government may by notification exclude. Which means power has been vested in the central government to exclude certain types of businesses which cannot be taken as LLPs at all. This was necessary in view of the fact that Reserve Bank of India has all along been stating that several private limited companies or several LLPs several private limited companies have converted themselves into LLPs, and several LLPs have been floated and they are undertaken non-banking financial activities. With there being no restriction under the LLP Act with respect to these activities, with there being no bar that any activity which has been regulated by some special regulators, majority of these several of these LLPs have been undertaking financial activities such as investments, driven of loans, etc. While 45IA of the Reserve Bank of India Act is applicable only to non-banking financial companies, and 45S of the RBI Act is applicable only to unincorporated bodies, there was no provision under the RBI Act which was applicable to LLPs as such. And RBI did not come out with any notification which said that yes, the provisions of for the purposes of the section 45S of the RBI Act, LLP would mean partnership funds. They did not come out with any such notification. So this particular change will now empower, and in fact the committee deliberated on this very issue, and I am very sure that very soon MCA will come up with a notification whereby financial services activities may not be permitted under LLP structures. So this definition of the term business now empowers the regulator to specify all those businesses which they don't want to be carried out under the term of limited liability partnership. Similarly, with respect to designated partners, one of them has to be a person resident in India. And there is a small change in the definition of the term of the expression person resident in India. Previously, a person was treated as person resident in India if he complied with the stay requirement of 182 days during the immediately preceding 1 year. That was the language used. Immediately preceding 1 year. So to decide whether you are a person resident in India, the number of days that were required to be counted was 182. And these 182 days were required to be counted in the immediately preceding, not in this particular year, but in the year preceding this year. And now whether the term year, since there was it is not stated as financial year, the term year would mean calendar year. But now there is a change, and they clearly say that a person will be treated as resident in India if he meets the stay requirement of 120 days during the financial year. So it is in this financial year, if he is meeting the stay requirement of 120 days, he will be treated as person resident in India. So what appears to be a very small change really has a threefold implication. And we have to understand it very, very carefully. If you look at the other amendments, the amendment that has come in with respect to rectification of name. Well, I'll not go into the procedural aspect of it, but let me tell you. Section 15, subsection 2 of the LLP Act said that an LLP could not be registered by a name which is either undesirable or which is identical or too nearly resembles to that of any other partnership firm or LLP or body corporate or a registered trademark or a trademark which is the subject matter of an application for registration. Now, a name which is similar to any other partnership firm. Partnership firms are required to be registered, they may not be registered. How do you really see whether your name is resembling the name of a particular partnership firm or not? There is no database of partnership firms. Trademark, which is the subject matter of an application for registration. It is not only registered trademark, but even trademarks which are subject matters of application, even those names could not have been arranged. This was really causing great hindrance as far as names of LLPs are concerned. And then if you look at section 17, it stated that where the central government is satisfied that the LLP has been registered by a name, which is a name referred to in section 15.2. Now see section 15 subsection 2. Section 15 subsection 2 covers both the cases. Name which is undesirable and name which is identical or too nearly resembles. And then they have a clause B which says is identical with or too nearly resembles the name of any other limited liability or body corporate or other name as to be likely to be mistaken for it. Now this is identical with or too nearly resembles the name of any other limited liability partnership or body corporate was already covered by section 15 subsection 2. It was only a repetition again. It was causing some amount of confusion. And then there was no time limit prescribed in section 17 as to when this application could have been made. And then you have another section 18, which says any entity, if an LLP is registered with a name which resembles the name of any entity, then that entity may apply for rectification of name of this LLP which has been formed subsequent to the formation of that entity. Now this was creating much more, and the time limit within which that entity could have applied was 24 months, but that was also creating a big problem. Amendments have been made to section 15 and section 17 to rationalize these provisions. Section 18 has been done away with because it was very, very widely worded. Any entity could have come in and objected to a particular name, could have said that, yes, I am already existent with this particular name and this company, this LLP's name should have been changed. Now, the amended section 15(2)(b) says that you cannot be registered by a name which is undesirable and which is identical or too nearly resembles the name to that of any other limited liability partnership or a company or a registered trademark. Only three things. Your name should not resemble name of another LLP. Your name should not resemble or should be too identical with the name of another company, or it should not be identical with or resemble the name of a registered trademark of any other person. And section 17 says that if out of inadvertence you are registered by any such name, which is resembling that of any other limited liability partnership or a company, or resembling a registered trademark of a proprietor, then the central government may direct such limited liability partnership to change its name within a period of 3 months from the date of such direction. Now, this application to the central government can be made by a proprietor of a registered trademark, and there is a limitation period for making such application by the proprietor of a registered trademark. It is 3 years from the date of incorporation or registration of change of name of LLP. I must tell you that there is no limitation period as far as suo motu exercise of powers in a case where the name is resembling or identical with that of any other LLP or with that of any other company. Only when the name resembles a registered trademark of a proprietor, then there has to be an application of the proprietor of the registered trademark, and there is a limitation period of 3 years from the date of incorporation. And then there are penal provisions if the directions of registrar of companies are not complied with. Changes have been made in rules to provide for the manner in which the rectification of name would take place. Now, while I don't have to take you through the entire procedure, what is interesting is that if an order is made for rectification of name, and if the order of the regional director is not complied with within a period of 3 months, then without any further act or deed, the name of the company will stand changed to ORDNC, which is Order of Regional Director Not Complied, followed by the year in which the order has been made, say 2022, followed by serial number of the order, followed by the existing name, LLPIN and LLPIN, and that shall become the new name of LLP. And fresh certificate will have to be issued by the registrar of LLPs for such change of name. And not only that, that LLP under section 21 in respect of all its invoices and official correspondences and publications always has to make a statement below its name that the order of the regional director has not been complied with. Now, this is really a very onerous requirement, and if any such change takes place, I'm sure either appeals would be made before the High Court invoked in its jurisdiction, or maybe changes would be done by LLPs within the prescribed period of 3 months. This is a step. I think with these kind of rules in LLP, perhaps it's an indication that similar provisions would also come in the Companies Act, where under section 16, if a direction has been made for rectification of name and the same has not been complied. There have been several changes with respect to decriminalization of offense. When we are talking of decriminalization of offense, we are stating that offenses will not be subjected to outside adjudication, will not be subjected to prosecution, outside prosecution. Itself. There is a difference between fine and penalty. While fine can be levied by in-house administrative authority, while penalties can be levied by in-house administrative authorities, fines can be decided only upon trial and only upon by a competent court. And hence, in case of fines, it is either only compounded as possible, or maybe a trial at the criminal court has to be faced. But as far as penalty proceedings are concerned, and fines and compounding, they have their necessary implications. But as far as penalties are concerned, they are much easier, they are easy to understand, they are easy to administer, and the administrative authority of the Ministry of Corporate Affairs itself can levy such penalties. So several such sections where punishment was provided by way of fine. If you see section 10, which is in respect of contravention of section 7 and 9, you will see that earlier it was punishable with fine, and now it is punishable with penalty. Similarly, if you see other sections like section 13, which deals with registered office, section 21, which deals with publication of name, 25 with registration of changes in partners. In all these cases previously, all these were punishable with fine, and now they are all punishable with penalties. Similarly, section 34, which deals with maintenance of books of accounts and annual return, 35, compromise or arrangement, 60, 62, reconstruction or amalgamation of LLPs, and 74, which is general penalties. In all these cases, you can see earlier it was punishable with fine, some were punishable with 25 lakhs, extended to 5 lakhs, some were punishable with fine which could extend to 1 lakh rupees. Now they all are being subjected to a penalty of amount specified in those respective sections, which means they are now being subjected to in-house adjudication mechanism of the Ministry of Corporate Affairs and will not have to suffer the tyranny of prosecution, or maybe doing for composition of offenses where it's possible to subject yourself to the adjudication mechanism. Since majority of these sections, fines have been replaced with penalties, it has also become necessary to provide for detailed procedures relating to in-house adjudication process. As you can see, offenses which are punishable with penalties, they will be subjected to in-house adjudication mechanism. Offenses which are punishable with fine only, they are compoundable by the regional director, and offenses which are punishable with fine or imprisonment, fine and imprisonment, they are not compoundable and special courts will deal with. Special courts is one more new concept that has been introduced, and special courts will deal with those offenses. Now, if you look at the adjudication of provisions relating to adjudication of penalties, a new section 76A has been introduced. And this vests power in registrar of companies to adjudicate penalties. Now, interestingly, if you see the manner in which the section is worded, it says that the adjudication authority officer may, by an order, impose penalties on the LLPs, its partners, designated partners, and any other person. Now, this phrase, any other person, was really disturbing me. I scanned through the entire LLP Act to see whether there is any provision in the LLP Act which makes any other person liable for any default committed under the LLP Act, except for Section 74, which deals with general penalty. I have not found a single section where any other person is liable for a default committed under the LLP Act. So if it is, maybe this any other person refers to, and I still fail to understand, even under Section 74, who that any other person could be. But since there is one section which deals with punishment for any other person, then this 76A rightly refers to any other person as well, on whom penalties can be imposed by the adjudicating officer by an order. Now, of course, while he is adjudicating penalties, he will give you a direction to rectify whatever default you have committed, and he will also provide you with a reasonable opportunity of being heard. Now, interestingly, if the penalty proceedings are in respect of non-filing of statement of account and solvency, then it is provided that if such statement of account or solvency is filed before or within 30 days of the notice issued by the adjudicating officer, then no penalty should be imposed. And a new concept of small LLPs has been inserted. Startup LLPs has also been inserted. And it is also provided in this particular section that penalties for these small LLPs or startup LLPs would be half of what is provided in the respective sections. So there is a concession provided to small LLPs and startup LLPs. We will see what small LLPs or what startup LLPs are. But yes, they are being provided concessions in respect of penalties, in respect of payment of fees, filing fees, additional fees, etc. Now, Rule 37A lays down the details procedure as to how penalties, how application has to be made. Now, you have to, AO will issue you a show cause notice. You will have to give reply to that show cause notice. Reply has to be given within 15 days. The show cause notice has to clearly state the maximum amount of penalty that can be imposed. Then your reply to the show cause notice has to be in electronic mode only. This is very interesting. The reply to the show cause notice has to be only in electronic mode. Now, interestingly, the word electronic mode has not been defined either in the Companies Act or in the LLP Act. There are references to electronic transmissions in the Companies Act. Perhaps we will draw references from those only to understand what electronic mode is. But yes, the reply has to be given by an electronic mode only. The period of 15 days, it can be extended by another period. Thereafter, if you want a physical hearing, you can ask the AO to review a physical hearing. Or if the AO feels that there is a necessity to review a physical hearing, he will provide you a physical hearing. Order on adjudication application has to be passed within 30 days of the reply period. If there is no physical hearing, and if there is a physical hearing, then order has to be passed within 90 days of the reply period. And authorized representatives are allowed to attend the physical hearings. So a complete and detailed procedure is given in Rule 37A. And this is a really welcome change, because most of the offenses will now stand decriminalized and they will be subjected to penalty adjudication by the adjudication authorities. A question may arise here as to what will happen to offenses which relate to period prior to 1st of April 2022. Will they be subjected to the earlier provisions, or will they be subjected to the new penal provision whereby penalties have been prescribed and fines have been substituted by penalties? The law is very clear as far as this issue is concerned, that whenever there is a penal provision, the beneficial penal provision will apply to the parties. If we feel that yes, penalties, the present penalty regime is suiting us, we can opt for the present penalty regime. But in case you feel that the earlier fine provision, and if you're going for compounding in respect of those fine provisions, you will be better off. You can even opt for that, and you can apply for compounding, because the time when the offense was committed, at that point in time, if the penal provisions provided for fines only, and if those fines only were compoundable, then perhaps you can opt for that as well. You have to see whichever is beneficial to you, you can opt for that. It is not necessary that yes, once penalty provisions have come in, you cannot take advantage of the earlier provisions if they are more advantageous to you. As you can see, appellate authority is the regional director, time period, manner in which appeal has to be filed, fees, all this has already been provided in Rule 37A, as I have already told you. Now, what are the offences which can be compounded? Section 39 has undergone a major change, and it says that only offences which are punishable with fine only can be compounded, which means offences which are punishable with imprisonment or with fine, or which are punishable with imprisonment only, or with both imprisonment and fine, they cannot be compounded. And if you look at the statistics, there are non-compoundable offenses for making false statement in incorporation documents, carrying on business with fraudulent intent, making false statement in your returns, your statement or documents, non-compliance with adjudication orders. These are all non-compoundable offenses. Whereas majority of the offenses are now compoundable, whether it is section 20, 34 sets, 38, 47, 76A, because in these cases, the offense is punishable with fine only and can be compounded. Like the Companies Act, if an offense has been committed by an LLP or its partners within a period of 3 years from the date on which a similar offense was committed by the company or its officers, which has been compounded, then you cannot make an application for compound. In other words, if you have today brought an offense compounded, please understand this, then within the next 3 years, you cannot get similar offense compounded. Now, today, if I have brought an offense compounded for the year 2017-18, I cannot compound a similar offense for the period 2022-23, 23-24. But if there is an offense which has been committed in 2018-19 or 19-20, which is prior to the date on which the order of compounding has been passed, this particular clause has no bar on those offenses. It is only 3 years from the date on which similar offense committed by the company or its officers have been compounded. After the date, 3 years after the date on which similar offense has been compounded. So if the compounding has been done today, from today thereafter, if there is any offense which is being committed, then those offenses cannot be compounded. But if there is an offense which has been committed earlier but was not compounded earlier, those can still be compounded. This again, section 76A deals with the manner in which compounding of offenses will take place. If you see what is compounded, I don't think we need to go through. There are various, under various laws, there are provisions relating to compounding. And compounding can be done by the regional director. Application for compounding has to be made by LLP, its partner, or its designated partner. Here, any other person is not being used. So it is only by LLP or its partner or its designated partner that an application for compounding has to be done. And while compounding, like the ROC while adjudication, the regional director may also direct filing of documents, registration of various returns which have not yet been done. He may direct that. So if there is any default, application has to be made to ROC. ROC will forward the application. along with installments, and RD will have to pass the compounding order. Compounding fee has to be paid, and then an intimation has to be filed with the registrar of LLPs. In case of companies, yes, joint applications by several persons has been allowed by National Company Law Appellate Tribunal in several cases. Pahuja Tati Seed Limited case being very, very prominent. Similarly, joint application for more than offense or for more than 1 year has also been permitted in the same judgment of NCLAT. So this is also possible in case of LLPs as well. Whether method of default is mandatory or not, but if you look, yes, it is an inherent requirement. An application will have to, like in GNL1, when you are making an application for compounding for companies, you have to state whether the offense has been made good or not. Similar provisions will also exist here. Factors which are to be considered for compounding. In VIV Solutions India Private Limited case, and CLAT has laid down various factors which have to be considered. And what would be the compounding charges? There has been several debate in NCLT and CLAT as to how much of amount should be levied as far as compounding amount is concerned. But Section 39, subsection 1 makes it very, very clear that the amount can extend to maximum fine provided for the offense, but shall not be lower than the minimum fine which has been provided for the offense. So between the minimum and the maximum, the compounding authority can take guidance from the various decisions of CLAT which has been passed in this regard, or on its own wisdom can decide what would be the compounding amount which he should levy for various offences committed by the LLPs. As I said, a new concept of small LLPs has been introduced, and small LLPs have been defined as those in respect of which the contribution does not exceed Rs 25 lakhs or such higher amount, of course not exceeding 5 crores as may be prescribed. Turnover in the immediately preceding financial year does not exceed 40 lakhs. It meets such other requirements as may be prescribed. Rules are to be framed in this regard. Fulfills terms and conditions as may be prescribed. Rules are to be provided in this regard. Now, startup LLPs, this is again mentioned only in Section 76A, and it is defined in explanation to Section 76A, which deals with the adjudication of penalties, which says that startup limited liability partnership means a limited liability partnership incorporated under this Act and recognized as such in accordance with the notifications issued by the government from time to time. So if the government recognizes certain LLPs with certain parameters as startup LLPs, those will be treated as startup LLPs, and the provisions of the Act, whichever are applicable to startup LLPs, will apply to them. Now, penalties, filing fees, additional fees, as I told you earlier, penalties have been reduced to half in case of small LLPs and startup LLPs. Similarly, filing fees and additional fees are much lesser in case of small LLPs, and so these have to be taken care of. And if you are a small LLP, then you can take advantage of these lesser fee and lesser filing fees required. There is a provision which has been introduced to enable Section 34 to empower the central government to prescribe accounting and auditing standards for LLPs. In fact, there are already accounting standards which are for small companies, which are for MSMEs. And there was really a big debate as to why these should not be applicable to LLPs, why these accounting standards should not be applicable to LLPs. If you look at most of these accounting standards, they refer to entities. And though there was no specific accounting standard for LLPs, now Section 35(4)A will empower the central government to prescribe which accounting standards and with what modifications will those standards, accounting standards or auditing standards will apply to classes of LLPs. Of course, this has to be done in consultation with the Institute of Chartered Accountants of India and on the basis of recommendations of LAFRA. There are provisions which have been introduced with respect to establishment of special courts. As I said, if the offences are non-compoundable, they will go to courts. dependent on the maximum amount of punishment, whether it is for less than 3 years or more than 3 years. It will either go to the magistrate's court or to the sessions court, which has been designated as special court under section 67A to 67C of LLP. A new section 77A has been introduced for stating that offences can be taken cognizance of only on the basis of a complaint made by the registrar of LLPs. Similarly, the office of the registrar of LLPs would be established under section 68A. And as you know that there are several provisions in the LLP Act where the National Company Law Tribunal is empowered to pass orders. For example, section 31, 41, 43, winding up of LLPs, compromise arrangements or LLPs, etc. Now, section 72(2) of the Act has been modified to clearly lay down the manner and time within which appeal can be preferred to the National Company Law Appellate Tribunal against the order of the National Company Law Tribunal. In case of additional fees, the present requirement of paying 100 rupees per day has been done away with. And similarly, additional fees are prescribed in the rules, and different additional fees have been prescribed for different documents or for different classes. For example, in case of small LLPs or startup LLPs, the additional fees is lesser. Similarly, even the filing fees in respect of small LLPs or startup LLPs is much lesser. A very small change has come in section 62(4) clause explanation 2, where they say that an LLP shall not be amalgamated with a company. I mean, just to give you a brief background, there was the Chennai judgment in Real Image LLP's case where merger of LLP with a company was allowed, and when this matter came up before NCLAT on 4th of December 2019, the law became much, much clearer that LLP cannot be merged with a company. This has now become, there is now a statutory restriction by virtue of amendment to section 62 subsection 4, which clearly says that an LLP shall not be amalgamated with a company. So the decision of National Company Law Tribunal has been given legal recognition, which otherwise was judicially binding on all of us, has now even become part of the statute. A small change has come in the rules whereby signing of statement in respect of signing of statement of account and solvency or annual return. This is necessary because of the Insolvency and Bankruptcy Code. As you are aware that Insolvency and Bankruptcy Code, the provisions of Insolvency and Bankruptcy Code extend to LLPs as well. In fact, since 2016, they have been in place for almost 5-6 years now, but still there was no provision with respect to the signing of the statement of account and solvency during the CIRP period in respect of LLPs, or the annual returns during the CIRP period. And now Rule 24(6) and Rule 25(2) has been amended to clearly provide that statement of account and solvency or the annual return on behalf of the LLP can be signed either by the insolvency professional or the resolution IRP, or by the resolution professional, or by the liquidator, or by the LLP administrator if it is under winding up under the LLP Act. Sandeep, do I still have time? Right.
Yes. Please continue.
5-7 more minutes because I think I've already exhausted 40 minutes of my time.
Yeah. Please continue, sir.
As I said, under section 67, notification has been issued under section 67, and several provisions of the Companies Act have been made applicable to LLPs as well. One of the most important section is section 90, which deals with significant beneficial owners. Now, there is a blanket replacement of the word shares with contribution, company with LLP, member with partner, officer with partner or designated partner. And this is how the section looks after it being replaced by these words. But there is an absolute, I mean, we know that yes, very soon the ministry will come out with the rules in respect of SBOs in case of LLPs as well, like we have in case of the Companies Act. Today, the rules which are applicable to the Companies Act may not be applicable to LLPs, and hence there has to be a clear-cut rules as to how and in what manner an SBO, for example, an SBO would be considered in respect of partners which are not partners who are not individuals. For example, another LLP is an LLP is a partner of an LLP, and if that LLP again has another LLP which is its partner, or if it has two individuals who are husband and wife, or who can be presumed to be acting together, how would SBO would be taken? Whether and there, or suppose there are three people and two of them together have a combined strength of more than 50%. How SBO would be considered, or how SBO would be determined in those cases is something which only rules can clarify. But if we take guidance from the rules in respect of companies, then perhaps the majority rule will still be applicable to LLPs as well. But we will have to wait for some time before the rules in this regard come in to really understand how the SBO provisions will be applicable in respect of, or how they will be administered in respect of LLPs. If you see now, if any individual, whether acting alone or together, through or one more persons or trust, including the trust or person resident outside India, holds beneficial interest of not less than 25% in contribution of LLP. Now, this right to exercise or actual exercising of significant influence are controlled as defined in Section 227. Now, this again is something which we have to see as to in what manner these will be treated for LLPs. What would be the guiding principles to determine an SBO in respect of LLPs? These are all matters of detail, and these details would be available when the rules come in. From the section, it is very clear that yes, if any person is holding beneficial interest of not less than 25%, then an SBO declaration has to be made in respect thereof. Similarly, under Section 164, which deals with disqualification. Now, this is how the section will look, that a person will not be eligible to become a designated partner of a LLP if he attracts any of these clauses from A to I. And if he does, then perhaps he will not be allowed to be, he will not be eligible to be appointed as a designated partner in case of LLP. Now the issue is that is it only in designated partners can only be individuals, and it is only designated partners. It is only in respect of designated partners that the disqualification would be attracted, not in case of partners as such. Now, if you remember Section 164, subsection 2, which is applicable where a company has not been able to deposit its financial statements for a continuous period of more than 3 financial years, or fail to repay the deposits accepted, or redeem any debentures or pay dividend. Now, if you look at the amendments that have come in with respect to LLPs, it says that which has not filed financial statements or the statement of account insolvency or annual returns, as the case may be, for a continuous period of blah, blah, blah. Now, has not filed financial statements. The word financial statements is not applicable to LLPs. It is applicable only to a company. Now, Section 164(2) now reads, no person who is or has been a director of a company or a designated partner of an LLP, as the case may be, which has not filed financial statements or the statement of accounts. So even if a director of a company does not comply with 164(2) requirements in respect of a company, he will not be allowed he will be disqualified as a designated partner in case of LLPs as well. Similarly, has failed to repay the deposits accepted or redeem the debentures or dividend. These are all applicable to companies. They will have no application in case of LLPs. So if you are a director of a company which has failed to repay deposits, then you are also barred. You are also disqualified from being designated partner in case of LLPs. Number of designated partnerships, there is a restriction. The restriction of 20 is now applicable to designated partnerships as well. Similarly, vacation of office, the requirement and the provisions of section 167 as they are applicable for vacation of office of a director are also applicable to vacation of office in case of a designated partner. Inspection. Now, limited inspection is now possible in case of LLPs as well. Section 206 subsection 5 and section 207 subsection 3 have been made applicable in case of LLPs as well. And in which case, it is possible that the books of account, books and papers of a limited liability partnership can be inspected by an inspector appointed by the Ministry of Corporate Affairs. While defunct LLPs could have been made defunct, the provisions relating to restoration did not exist. And now section 252 has been made applicable in respect of LLPs as well. So restoration of a defunct LLP would be possible by invoking the provisions of section 252. As I said, there is already a section which has been introduced to define cognizance of an offense, and hence section 439 of that has also become applicable to LLPs as well. So friends, these are the major changes as far as the LLP Act is concerned. Only one issue that I would again like to highlight and again like to bring to your kind attention is that one major recommendation that was made by the committee with respect to non-convertible debentures has not found place in the Amendment Act. The committee had elaborately discussed the need for allowing LLPs to raise money by non-convertible debentures. They have even gone to the extent of saying that several SPVs in real estate sectors are floated as LLPs to take on various projects. And there is a need for raising funds. And there are several alternative investment funds which are willing to put in money in these SPVs, but only by way of an instrument. And since the route of NCDs are not available to LLPs, it is really becoming a major impediment for LLPs to raise resources. And hence the committee had recommended for raising of monies through NCDs. That unfortunately has not found a place. Otherwise, it's a welcome change that has come in. Thank you, Sandeep, for giving me this opportunity. And thank you all for a patient hearing. If you have any questions, at the end, I would like to answer whatever questions that I will take. Thanks.
Thanks, Manoj, for your kind words with regard to LLP amendments. We came to know so many words, like some work can be excluded for LLP. LP and company cannot be merged. Some relaxation for the small company and started LLPs. And I hope that there is no relaxation for the small company in the Companies Act. The other words we came to know about any other person. Other words we came to know about the SBO for the LLP. If many of the provisions of the Companies Act are coming in for the LLP, then why some working will be excluded in LLP? So many words, so many questions. Manoj, we'll talk with you later on during question answer session. Now we all are waiting to hear our esteemed speaker, C.S. Dhanpala sir. C.S. Dhanpala sir, please.
Yes. Good evening to all.
Welcome you once again, sir.
Yes, sir. Good evening to all. And our earlier speaker friend, Manoj, he made my job simpler, but given a responsibility of dealing with the implications. And of course, he has explained in depth all the amendments within the timeline, whatever was possible to him. He really has explained well. And of course, a few points what he has shared. In fact, I wanted to share, of course, he's shared that point. So I will try to more focus upon the implication, which is a responsibility that he was expecting from me to take care of that aspect. So I will take you through my PPT. Before that, So now, the Limited Liability Partnership Act, as you all aware, though the Partnership Act sounds Limited Liability Partnership Act 2008, but it came into effect, as you all aware, 31st March 2019, then ruled on 1st April 2019. As our friend was referring, there was no amendment at all in the Act per se. Of course, there was a notification issued, certain provisions of winding up, and two specific sections was introduced to made applicable. Continuation section and another delegation section only was made applicable to the limited liability partnership. So other than that, for a long time the ministry was not touching upon these provisions of limited liability partnership. But now the situation it arose today that the LLP has to be given importance. The reason being, as you all aware today, the registration of LLP, to my knowledge, is more than 3 lakhs, I believe, which I heard from one of the interview from MCA Joint Secretary. So almost more than 3 lakhs LLPs are there. Today the companies, as equivalent to the companies, the LLP also has gained a lot of importance. Before getting into the amendment, so if you have to see, as you all aware that, this is a hybrid concept of Companies Act as well as the partnership form. So where always we say that it has got a legal sanctity of the company and what is provided under the Companies Act, and also it has got a flexibility of the Partnership Act in certain aspects. That's why we always refer it as a hybrid kind of a entity, the limited liability partnership, which carries the legal protection, impact of the Companies Act, as well as the liberty that's been given to the Partnership Act. Of course, the LLP is a body corporate, as you all aware, just like a company. Now, since the number of LLP registration got increased drastically, I think day by day it's getting increased. So government felt it now that important that, okay, let us bring a recent amendment. Of course, furthermore amendments also we may expect, because as you all know, when more LLP comes up, so it becomes more responsibility on the part of the ministry to regulate, just like a company how they are regulating, to regulate, and also more particularly in the entire amendments, which I will be taking through for the next few minutes. I have to say it's a real blessing is a reduction of fees and penalty. That's a real blessing, where when the time the per day additional fees of ₹100 was introduced, we were all discussing in the professional forum where the registration was very less in those days. I'm saying some 3-4 years back, I have to say. Then now in mid of this, the ministry is introducing ₹100 additional fees. That will furthermore hamper the the motivation of the stakeholders to come out to their limited liability partnership, means to come and to start a limited liability partnership. But now, in fact, the government really understood that the importance of the limited liability partnership, as well as today a lot of projects and many business community has understood the importance and the legal sanctity and protection that a limited liability partnership. So they prefer to go into the limited liability partnership. That's why today we are in sitting into this particular topic of recent amendments. In fact, though it's recent amendments, it's not the amendment on the Act. I'm planning to take you through the recent amendment rule also. There are two amendment rules. In fact, the latest second amendment rule has already come into operation with effect from 4th March 2022. Of course, all other amendments are coming into effect with effect from only from 1st April 2022. With this introduction prelude, I thought I can take you to the PPT. As I was, the organizers as well as the friend, he was referring to talk about impact. I'll keep some last 15-20 minutes or maybe 10 to 15 minutes to discuss on the impact of how it is really going to work for each one of us. I'll though may look like a repetition, but still the aspects which I'll be taking you through, or I'll be deliberating, maybe little different comparing to our friend what he has taken. So I will try to see that what are the amendments, though there are the deliberation would be, and the amendments changes would be the same what our previous speaker has covered, but still I thought in my way of thing, I thought what I could able to add, give a value addition to that. I'll try to do that. I'll take you through the important amendments, what is recently taking place, which is already come into effect, which about to come into effect with the effect from 1st April. And also, before closing my session, I will take you through some impacts. Then we will go on to the question and answer. And more of impact, I wanted to discuss, no doubt. But before that, I'll just deliberate few points on the amendments in the sections and rules. In fact, as you all aware, LLP Amendment Act passed on 13th August. And of course, as you know, this present LLP Act before this amendment, it carries only 81 sections. Okay. In fact, after this amendment comes into effect completely, then, of course, with effect from 1st April 2022, the LLP Act is going to have within it 85 sections against 81 section today. So out of these amendments today, if you see, there it totally contains this LLP Amendment Act 2021 29 sections. That if you see, 7 new sections are inserted. Okay, I'll show you what are those new sections which got inserted, and also 5 sections got substituted. Then 3 sections omitted. I'll tell you those sections that are very important. Section 72 got omitted. I'll tell you that what is the impact of it. Then, if you see, this entire notification LLP Amendment Act is going to come with effect from 1st April 2022. Of course, today the time has come where everything has become a web-based. Of course, you will be knowing it. Of course, all our stakeholders may be struggling with the association of DSC with the web portal, but all this mid of all these practical issues. But today we can appreciate that today the LLP also is going to go into the complete web-based. If you see the Companies Act, only in the incorporation portion has completely been made as a web-based. Okay, though rest of the other things, forms filing, said to be made, but here I believe this way only as a matter of trial and error, or of course to see the impact or to improvise the system. The ministry would have thought that first we'll bring entire thing in LLP Act web-based. Then probably slowly they will try to make the entire Companies Act also going forward as a web-based. May happen or may not happen. But probably today nobody would have dreamt of, or I never thought of that the entire LLP will become a web-based on a particular day. But today we are there, and the entire web-based form has been introduced, and we are really going to, of course, with the initial glitches, whatever there, it will be there for any. Of course, we faced at the time of 2007 when the MCA got migrated from physical mode to online. So like that, there will be a same way incorporation spice forms when we are dealing with the stakeholders would have struggled. Similar way, there will be some initial teething issues, but of course, over a period of time, it will get settled. Hopefully, the ministry will understand the issues of the difficulties of the stakeholder and give further time on that. Now, taking you through LLP Amendment Act. If you see after the Amendment Act comes into effect, the LLP Act is going to go from 81 sections to 85 sections. Fine. So what is the necessity of this amendment? What is the purpose of it? And what the real aim of it? We will see it little later. Before that, I will take you through the highlights. So what are the real purpose of these highlights? It's, if you see, these are the actually speaking, the important areas or important benefits or highlights, whatever we call it. These are the important things that government or ministry, of course, based on the company law committee, which our friends earlier speaker has shared in detail about the committee's observation and what has come and what has not come. All is briefed. So I don't repeat it again. So now if you see that the important changes that has come into effect are going to become effective with effect from 1st April 2022 is decriminalization of offences. So what we always understand, decriminalization of offences is nothing but what the ministry has made us to understand is to making fine as into penalty. That's the decriminalization of offences. It's not that making a punishment into fine or penalty. Okay, it's not a decriminalization. Though the word criminalization is used, probably they would have picked up to make it understand that the law is made a little, the law, the implements of the provisions of the law is getting in a lighter side, probably to give that impact or that feeling. The government would have thought, okay, we'll use the context called decriminalization of offences. So it is all about, I'll take you through the details of the whatever the fine that has today has become a penalty. The same exercise has been done by the Ministry of Corporate Affairs, as you all are aware, to the Companies Act also, which we are following in the provisions of Companies Act, where earlier it was a fine which has got replaced as a penalty. The same exercise today, now the ministry has ventured into the LLP Act, where they made a few sections from fine to penalty. I'll take you through in detail what are those sections. And very importantly, as I was telling, the provisions of Section 72, what I was referring, that it's very important provision. In fact, rather it is about the penalty 73. Penalty on non-compliance of any order passed by tribunal. In fact, that penalty aspects with respect to non-compliance of order of tribunal, it's completely, the section itself is omitted, is removed. What is the impact of it? Because, of course, let me try to explain here so that other aspects I can explain a little later. So what would be the impact of it? Removal of punishment with respect to non-compliance of SL. What the ministry conveys by this, or what they are trying to convey to the stakeholder, whether they won't be enforcing it in case of non-compliance under Section 73, how it says, since the penalty has been removed on non-compliance of any order passed. It's not like that. The idea would be that since there is already a contempt of court act is there, which provides for punishment for any non-compliance of the order of the court. Today, as you all are aware, after the Companies Act 2013 has come into effect, the tribunal has given a statutory recognition where the orders of tribunal, if it's not compliant, that amounts to contempt of the court, which is not the same privilege or legal protection sanctity was not there in 1956 Act for the Honorable Company Law Board. But whereas if you see today, the Honorable National Company Law Tribunal has given that legal status wherein it's as referring to the court, it is given a legal status where the order, if it is not complied with, that will be deemed as a contempt, and it can be taken, and the person will be subjected to the jurisdiction of the Contempt of Court Act. And of course, it provides almost the imprisonment to a tune of up to 2 years. So idea would be that not that to remove it and give a signal to the stakeholder that no, we are not worried about the non-compliance of NCLT, tribunal and order. No, it's not that. They want to avoid the duplication. That should be the real intention of the ministry, to remove Section 77 from the LLP Act, whereby even if any LLP or any partner, they are not going to comply the orders of the tribunal, anyway, that will be viewed as a contempt of court under the Contempt of Court Act. And the action will follow, and they will be subjected to the imprisonment after following the legal process as contemplated under the Contempt of Court order. So that should be the purpose where they removed. Because I keep hearing in various webinars, where online YouTube webinars, where it's getting projected that they removed the provisions relating to non-compliance of tribunal order. So they diluted No, it's not, they have not diluted at all. In fact, I have to say that the duplication is removed actually. Okay, I don't think any similar provision are there under Companies Act. You can't find similar provision in the Companies Act for punishment for non-compliance of the law. No, because reason being the Companies Act gives a statutory authority to the NCLT that the order of tribunal amounts to contempt. Therefore, there is no separate section has been provided like in LLP Act. Now today the ministry would have felt that there is no requirement to have a section 73 where the under Companies Act and under statute, the NCLT order, the order of a tribunal amounts to non-compliance of it amounts to contempt of court act. So automatically it is taken care of under that act. So duplication should not be there. That's why they remove this section. Then adjudication of penalties. Again, our earlier friend has deliberated in depth on adjudication of penalties. In fact, it is now given to the register of companies earlier, which was as a compounding. In fact, this is the one of the initiative where decriminalization of offences have been done. As I was referring earlier, it's not that sentence they change as a penalty or sentence they reduce. It's not that way. In fact, I have to say other way around. Okay, I will take you to one important section. I think section 30. Okay, where the earlier imprisonment was only 2 years. Now it has been increased to 5 years. In fact, that if it is done with the intention to defraud the creditors, the government is not ready to give a soft approach. They are very clear. It is only a decriminalization of offences done only in a procedural side where there is a delay in filing form and procedural is if it is unintentional. But government is very clear. If anything is done with the ill motive, with the intent to defraud the creditor or injure the interests of the LLP or stakeholder, then government are very clear on that they are not going to reduce or give a soft approach on that. They already increased the imprisonment. I'll take you to that section when the relevant portion if I come. Compounding of offences. Again, if you see that earlier, as I was referring, that compounding of offences were there. Of course, the provision was provided only that if the power given only the section provides only a fine, then it is compoundable by the regional director level. And as I was referring earlier, if it is a penalty, it can be adjudicated by a register of companies by following the process. But if it is the provision says that in case of non-compliance of that particular section, okay, if it is fine, punishment or both, then it has to go to the special court under the provisions of the LLP Act. Same way, change of name, how the name has to be changed, and in fact, in much detail, our earlier friend has taken through detailedly and about how the application should be made by the trademark owner and what the scenario comes, and section 17, 18, he was dealt with in detail. I will try to take little on that part when question comes. And special courts, I have certain points on that special court. I'll take you little detail. Of course, here I was wondering that special courts, it keep lingering to me that even under Companies Act itself, the special court has not constituted as it. Okay, only the existing magistrate court is notified as a special court for the purpose of hearing the case of the cases which are coming under the Companies Act, or the offences that are coming under the Companies Act. Probably to enable the ministry to form a special court, going forward in future. So probably they would have given an enabling provision, they would have introduced. But I really surprised to know that whether that means the government, how serious it is, that it shows that the government or how they are very serious in addressing issues and how to deal with the offences, okay, when it comes to the court. That means though there is a special court under the provisions of Companies Act, but still the government wanted a separate special court under the provisions of LLP Act. In fact, if you see, there will be a separate special court under the Companies Act, then there will be a separate special court under the LLP Act. But the provision made it very clear that till the date the special court formed under the Limited Liability Partnership Act, the special court which has already notified, which is already acting as a special court under the provisions of Companies Act, will continue to be will carry on, will conduct, will try the offences, hear out the cases which are coming under the LLP Act also. So that provision is made clear that till formation of special court under LLP Act, the special court formed under the or whatever notified under the provisions of Companies Act today, that will be a special court for the purpose of LLP Act also. So we have to wait and see and what is the going to be. And there's a small difference in the special court aspect which I would like to say, where if you say the provisions of special court, if you see section 67A, 76A, in fact, I thought I should take you when I'm dealing with the much detail. 77A, 67A. It talks about the special court having offence of less than 2 years. I was surprised. See, it says that the special court which is constituted under the LLP Act, which will try offences, okay, and for a term not exceeding 3 years. Okay. If you see, under the Companies Act, the special court has been formed in a two different layers. One is the judicial magistrate court, which can try offences up to 2 years, one category, and above 2 years in another category under special court. But here, if you see the special court, what they are trying to refer here, the special court is capable of, if you see, notwithstanding anything contained, the special court try in summary by way of offence under this, which is punishable imprisonment for a term not exceeding 3 years, it says here. Okay. So, if you see that the special court, the section further says 19. In fact, I wanted to take you through the relevant portion. That's why I said I will take you through relevant portion. So, if you see there, it says 2 years, 3 years in the LLP. At the same time, in the Companies Act, if you see, there's a two different kind of court where one category of a magistrate court, which is deemed as a special court under the Companies Act, is empowered to try the offences, to hear the offences, cases, imprisonment with up to 2 years. Here it is 3 years. We have to see how this gap is bridged by the ministry. Of course, I will little deal with that when I take you through in a subsequent. I wanted to take you through the Amendment Act, how it has happened, what exact language it used when time permits. I wanted to take you through so that I wanted to make you to understand how it differs in the LLP Act and comparing to the Companies Act 2013, and how this gap, or probably how the understanding should be made, or probably the ministry has to come out and say in the sense of taking the offence or bringing the offence within the jurisdiction of the special court under the provisions of LLP Act, comparing to the provisions of Companies Act. I will little deliberate in much detail if time permits. And small and startup LLP, as our friend was referring, and startup LLP, it is not defined. Of course, under the adjudication provision, I could see in the adjudication provision and in explanation it is coming. Of course, our friend has showed in a previous session under section 76A, the startup LLP has not been defined anywhere, but it has been brought as a part of explanation under section 76A of the Amendment Act, where it says, for the purpose of this, the LLP incorporated under this Act, recognized as such in accordance with the notification issued by Central Government. In one of a webinar which I could hear, where the Joint Secretary has given a point on this particular aspect, which I thought share to you, he was referring that the startup LLP would be the LLP which is incorporated under LLP under this Act, and which probably take a register with the DIPP, okay, Department of Industry. He was referring that probably they may be in a discussion stage, or maybe they may be codifying to bring it out. Probably he was referring that when discussion on that amendment, LLP amendment, where he was referring that the startup LLP may be made to make application and get a license or whatever certificate, whatever it may be, under DAPP to recognize, to deem it as a startup LLP. Probably we have to wait and see when the ministry is really bringing out to make it clear, which would be deemed as a startup LLP, because that would be the question. I expect a question from all our friends, because there is no clarity in that aspect. Okay, what is startup LLP? So that's why, upfront, whatever possible, I trying to clarify in my deliberation itself. Probably, if any other questions also we can take. So probably we have to wait and see what kind of criteria that ministry is planning to bring out. Okay, with respect to deeming LLP as a startup LLP. A small LLP, as you all are aware, that there is already a provision in the LLP Act where if there is a contribution up to 25 lakhs and the turnover of so up to 50 lakhs, as I was referring, for auditing purpose, 45 lakhs for auditing purpose. Okay, where earlier it was whatever the criteria that was made applicable to the auditing. Okay, that means the auditing was not made mandatory. So same criteria has been brought to the small and small category of LLP, where but only one rider only is there, that I wanted to say what is that rider. 25 lakhs as I was referring, and 40 lakhs as I was saying in turnover, 25 lakhs in terms of contribution and 40 lakhs in terms of turnover. But today the threshold has been increased, meaning that the government is given a free hand where 25 lakhs can be increased up to 5 crores and the 40 lakhs can be increased up to 50 crores. That means we can wait when the situation comes. The ministry comes up with a notification whereby they will keep on increasing the threshold, whereby they are today given a means a liberty by virtue of this amendment act, where from the contribution of 25 lakhs to deem it as a small company, they may rise up to the 5 crores, but not beyond that. And at the same time, with respect to the turnover of 40 lakhs, they are given a liberty of raising the 40 lakhs to up to 50 crores. So you see the scenario, if the ministry is given a free hand, already is given a free hand by means of this amendment act to raise the 40 lakhs of turnover up to 50 crores. That means in future plan would be that the LLP having a turnover of up to 50 crores should also be brought under the definition of small LLP, which really enjoys a few benefits under the LLP Act. So I think in future, probably the amendment may come, a notification may come. We have to wait and see. But as on today, the same, what are the criteria for non-auditing LLP, which is now coming under the auditing purview, where 25 lakhs of contribution and 40 lakhs of turnover, the same criteria has been made as a criteria, a threshold for deeming LLP as a small LLP, with a liberty to the ministry to increase it to 5 crores in case of contribution and 50 crores in case of turnover. Similar way, standards of accounting and auditing standard, and here also they brought it, and slowly they are trying to improvise here. In fact, as I was referring that, just like a company is like a Schedule 3, and today I think ministry focus would be that to bring it more formalized, more structured way of financial statements for this LLP also. That should be the idea, that government thought that okay, probably they may extend the financial statement also to the Companies Act. Similar Schedule 3 kind of thing also they may try to bring it out in line with the Companies Act. The moment the registrations of more LLPs are, if the registration takes place, then ministry may probably think of bringing the similar kind of financial statement which today is followed by Companies Act. Slowly they may bring it. Probably as a first initiative, we may take that this government is planning to bring this standing accounting and auditing standards also to make it applicable to the LLP. Now, quickly taking you through this definition part, because I have a lot more to discuss. I think as I was friend was referring, that we need a lot more time of hours and hours to discuss each and every point. Of course, as a Jews, we can try to give whatever the real understanding of us, so that probably in the subsequent seminars, our institute would take initiative to bring it more clarity by some more seminars. So today, wherever I could find a gap or wherever I could want to understand, I'm trying to bring it before you, because as I was friend was earlier, he has explained almost many provisions of the act. I don't repeat it, so I'll try to bring to a notice wherever there's a gap. Probably it will be bridged, or probably ministry will come out with a notification, or wherever we need to correct our understanding. All these aspects I'll try to project them more than going into the core provisions of the Act, Amendment Act and Amendment 2. If you see Regional Director, it says the Act means a person appointed as such by central government for the purpose of Companies Act, for the purpose of this Act or the Companies Act, as the case may be. But here this thing I failed to understand. But the similar definition is not there in the Companies Act. In fact, I was browsing through whether any definitions, because after seeing the definition under the Amendment Act in LLP, immediately mind goes immediately what the Companies Act says. Then I was surprised to see I could not get any definition of Regional Director under Companies Act. I don't know, Ministry would have thought that, okay, it is settled position today. Everybody, all the stakeholders knows that there's a Regional Director. Why we need to specifically bring out a definition under Companies Act? I don't know, but there's no definition under the Companies Act what is Regional Director. On the other hand, if you see here, this refers Companies Act, meaning that Regional Director means a person appointed as such by central government for the purpose of this Act or Company Act 2000. That means if a ministry would have appointed a person as a Regional Director, even for the purpose of Companies Act, and the same office and same officer would be given an authority or will be empowered to deal as a Regional Director under the provisions of LLP Act. Okay, so that we could understand from the definition of LLP Act, but those similar definitions not there in the Companies Act. Of course, the registrar definition is there in the Companies Act, as we all know that registrar is a person, and it means all the joint and deputy and other assistant registrar also. So wherever in the absence of registrar, probably assistant registrar will step in shoes of the registrar. That's the reason the definition is given in very clear way. If you see here, Companies Act 1956, wherever the reference, okay, of the Companies Act 1956 is completely replaced, because even a few sections I could see, even earlier, as I was referring, there were 3 amendment, not amendment, I have to say notification, to make applicable the winding up provision, okay, to the LLP. Same way, provision relating to the delegation of power 67, which is there under the LLP Act, okay, by invoking section 67 of the LLP Act, they made it applicable the delegation power under the Companies Act to the LLP. Similar way, the condonation power also, which is available under the Companies Act, has been extended. So with these 3 notifications only, they made earlier the provisions of Companies Act applicable before this Amendment Act, what we are discussing today. So only these 3 notification has come to make Companies Act is applicable. Okay, but if you see here, even those notification, if you see those sections has been referred pursuant to the earlier Act, 1956 Act. Now, even that section also has to be seen in corresponding to the section Companies Act 2013 only. So that's the reason government has felt that there's no use of keeping the word wherever appearing in the Companies Act 1956 in the LLP Act for the purpose of LLP Act, and all should be replaced. So they brought the amendment replacing the Company Act 1956 has been replaced with the Companies Act 2013, which I was explaining, small LLP, the new concept which I already explained to you, 25 lakhs, 40 lakhs with the rider with a power to the ministry to extend 25 up to 5 crores and 40 crore lakhs up to 50 crores. 40 lakhs to 50 crores. Startup, this also I just gave an idea where that probably the provision yet to come, and they may ask the LLP, which is registered LLP Act, to take a license from a DAPP to deem it as a startup LLP, to give a status of startup LLP, and startup LLP has given certain benefits in terms of lesser penalty. In fact, small company and startup LLP is given a lesser penalty. It's a real relief, I have to say that, because that's a crucial thing for the entire stakeholder. For the stakeholder, what they actually be looking at, paying a lesser outflow. Okay, so if so, that would be the more encouraging to the stakeholder to venture into the LLP, and probably after this amendment comes into force, and all our stakeholders, the companies and the business community, if they come to know, probably they will try to venture more into LLP also, just like a company. Since today the penalty is reduced a lot more. Okay, so lesser penalties, as I was referring, comparing to the other LLP, non-small LLPs and non-startup LLPs, if you see small and startup LLP, the penalties are off penalty only, subject to a maximum 1 lakh. If you see, just for easy understanding, many of the provisions of the LLP Act, if you see, the penalty I could see in certain places 5 lakhs, up to 5 lakhs. But today, fortunately, the ministry has brought the many places the 5 lakhs is as 1 lakh, the maximum cap. Though in certain provision, the ministry says the penalty, of course, the penalty of rupees 100 per day, but still it is restricted up to 1 lakh. So that's really a welcoming thing that we have to really see. The ministry has taken real initiative to see that they are really attracting the stakeholders towards forming the LLP and conducting their business through LLP, rather than going to the unorganized kind of or unregulated structure called sole proprietorship or a partnership, though partially regulated partnership, but still it's not fully regulated. So in order to encourage that, there are two advantages. One is bringing them into LLP as a body corporate to keep control and regulate them. Other, to discourage them from coming out from an unregulated sector. Okay, so that's the advantage that ministry will get by bringing down this penalty value. So that stakeholder will show more interest in forming small LLP as well as startup LLP. Now, comparing to other, as I was referring, it very clearly says off penalty. Very simple. Okay, it is only off penalty that will be levied for the small and startup LLP. So this is really encouraging thing comparing to others. Same way, the maximum cap is a real motivation to all stakeholders in LLP and designated partner, where maximum cap to the LLP is 1 lakh and for the partners is maximum cap is 50,000 rupees. So they are little, they can relax actually once the entire provision comes into effect. If you see residual status, as is already been explained, it is now reduced to 120 days in the financial year from the earlier 182 days. Okay, these are the things. In fact, I have a lesser time, so I will try to quickly go through. I thought I can take you through all the Amendment Act. What exactly quickly I wanted to take you through Amendment Act, Amendment Rule, the piece how it was introduced, so that I can put more point on that. But let me see how much I can do. So offences relating to the designated partner, as I was referring, it's very simple. So this is the changes that have been made. Okay, the penalty earlier, whatever was there, whether earlier the penalty was 25,000 or it was 1 lakh. But if you see that now every partner shall be liable only up to 10,000 rupees, and in case of continuing contravention, the further penalty of 100 rupees for each day after first during such contravention, but subject to maximum of 1 lakh. That's what I was explaining to you earlier, that rather than going into each and every provision to understand how the fine got replaced as a penalty and how much it got reduced, we can try to understand majority portion is that maximum is 1 lakh for LLP and 50,000 for partners. So how much ever the penalty runs or continuation goes. So, but only thing is this is a maximum thing. Suppose per day runs up to 50,000, then 50,000 will be levied. Not that 1 lakh will be levied. So this is only a maximum. Similar way, as I was referring other provisions also, same penalty has been given. So to save the time, I thought I can move forward so quickly so that if you see the offence relating to the registrar office, there's a change where here if you see every partner is liable to a penalty of 500 rupees for each day. Here it's not 100. Okay, again it is another important change. And during which defaultment is subject to maximum 50,000 rupees for the limited liability partnership and its partners. So here the same, again the cap is applicable. Again, if you see in case of publication of name, again these are all coming under the decriminalization of offence. Okay, what are the changes that have been made in terms of fine into the penalty and in terms of reducing the higher value of fine to the lesser value of penalty. Okay, in case of contravention of in connection with the publication of name of LLP, if you see today the penalty will be that of penalty of 10,000 rupees. And same way here, change in partners, if there is a default or any non-compliance related to that, then the penalty again same 10,000 rupees. Again, if you see earlier, it was up to 25,000 rupees. Again, the same way relating to the changes in partners with respect to the subsection 1, it is 10,000 rupees against 25,000. Coming to the important thing that offences relating to the books of accounts and statement of accounts. Here, this is another important thing that we need to understand. The penalty of 100 rupees for each day during which the failure continues here. But here also the maximum cap is 1 lakh and for the partner it is for 50,000 rupees. I was referring that here everything almost they made it they made sure, means they ensured that it is restricted to 1 lakh and in case of partner it is restricted to 50,000 rupees. Same way the annual return also, if you see the same level they done up to penalty of 100 rupees and for each day and the penalty and up to 50,000 for designated partner in case of failure or non-filing of annual return and any offence relating to the annual return under the LLP Act. If you see the offences relating to compromise arrangement, similar way if you see that maximum penalty of 1 lakh and 50,000 for designated partner. So all are similar positions. So I'm quickly skipping up so that I can concentrate more other aspects that similar way for reconstruction and amalgamation also. And general penalties, of course, if you see the general penalty, earlier, if you see if there is no penalty provided in any of the section of the LLP Act, general penalty earlier, if you see fine which may extend to 5 lakh rupees, but which shall not be less than 5,000 rupees with a further fine of 50 rupees for every day. But if you see now, it is made it less, it shall be liable to the penalty of 5,000 rupees and in case of continuing contravention for the further penalty of 100 rupees for each day after continuing this thing. But that's why I said to keep it very simple in mind, the penalty in case of LLP, it is 1 lakh. In case of partner, it is maximum of 50,000 rupees. That is very easy to keep it in mind. Going next to the compounding offences, if you see, as you know that the RD can compound the offences only punishable with the fine only. The rest of the things should go to the special code, which I already explained. And penalty will be as per the minimum and maximum as per the respective provision there. And no compounding will be done within 3 years of the previous compounding, which our friend has explained also in the earlier session. Application to be made to the ROC who has to forward to the RD. This is very important to understand because generally in all compounding offences we directly file with the regional director. Okay, and here in case of compounding offences, application has to be filed to the ROC. Then he has to forward to the ROC has to forward to the regional director with respect to the compounding of offences. Post compounding, it is a requirement to intimate to the ROC within 17 days. Now coming to the adjudication of penalties. Here, ROC is given a power to adjudicate the offences punishable with the penalties. In case of, if you see, default relating to the filing of annual return or statement of solvency, here one rider is given, probably to encourage more annual filing. Probably the government has given a small relaxation whereby they will not charge a penalty if default is rectified, okay, either prior or within 30 days of issue of notice. This is available, please note, only for the annual return and statement of insolvency, and this is not applicable for any other adjudication process or any other non-compliance. This is only for the statement of insolvency as well as an annual return. So that means within 30 days, if it is rectified, then adjudication process will be stopped. So company will be in compliance. Fine. For small and startup LLP, as I was referring already, is of penalty. And of course, our friend was showing the rule also, how it should be done and what's the process to be followed for doing the adjudication process. Return show cause notice to be issued by ROC indicating the default. And of course, all this electronic mode alone, it should be replied. The reply should be given to notice only in electronic mode. And what is electronic mode? Our friend has deliberated in detail. There is no specific mentioning about electronic mode. We have to presume that it is the email communication that probably they meant to say that electronic mode. They mean to say. And the same way that if required, they will call physical appearance. In case they call for physical appearance, 90 days time is given for order to pass an order. In case they have not called for any physical appearance before ROC, then within 30 days they have to pass an order. This is the question that it covers. And ROC has power to summon. As you know that the similar like any other act, if you say that power of the civil court will be given the moment they start the process. So that's the power, same process, the power is extended, what is given to the, during the process of inquiry, the same power is being given during the process of adjudication. So ROC has the power to summon and enforce the attendance of person. Similar thing is applicable in 206 in the FUC and the Companies Act when the inquiry is commenced, and all these powers the registered company will have under section 206 and 207 of the Companies Act, where he can summon a person and make the physical appearance. All that same power is given during adjudication also. And other amendments, if you see, the liability for fraud, my God, it's very surprising to see. I really wanted to show the language of the fraud. I think how many of you better, I thought I don't want to stop the PPT and go to other portion, though, but anyway, I wanted to show this. It's very important someone to see. You will appreciate really the difference, what they are trying to do. This is section 13. Now, I want you to read the language, very important to know, because rather than going into routine understanding the things, there's certain things which is very important we need to understand. Here, this is a provision in the entire LLP Act. I could see the word fraud, of course, under provisions of Companies Act 447, 448, and there are any number of sections. There are so many number of sections which ends with a provision saying that failure of compliances will be treated as offence under liable for action under section 447. Liable action under section 447. Even our every form required to be filed under the provisions of Companies Act, we have a tag or a disclaimer, or we can say note below the form that in case of any discrepancy or any non-compliance, there will be filing the forms, and that will be taken to that will attract the action under section 447 under the Companies Act, which is a fraud, which is very detailed way has been defined more than any other act in our country, and Companies Act, which is defined in a very detailed way what is fraud. So every form you can see under the provisions of Companies Act, there's a note that if there's a non-compliance in filing a form and giving the detailed false information, then that will trigger and subject the person to the jurisdiction of section 447, 448 and the Companies Act. But whereas under LLP Act, fortunately the fraud side is very less. Means the focus given on fraud and other things is not that extensive as there in the Companies Act. But here I could see one section, section 13, which talks about unlimited liability in case of fraud. So here it opens up the liability of the person. My God. it's very important to understand the concept of limited liability partnership itself is lifted here. Because the idea of limited liability partnership itself is that to give a protection of limited liability. Okay. When the concept is lifted, that means the limited concept is lifted and exposed to unlimited liability, then it's as equivalent to the partnership form. It will become as equivalent to the partnership form. So government is very clear. Okay, in the event of any act carried out by either by LLP or a partner to defraud the creditors, or in fact here it's very important to understand. Please, very carefully you have to see here. It is not only to defraud the creditors of LLP or any other person. Okay, that's the same. Any other person there appears in 447 and a Companies Act, which defines what is fraud. There, against any other person, by any other person in relation to the affairs of the company under 447. So 447 is completely open. It's open-ended, all the sides. Okay, offense done by, committed by any person, by any other person. But here, if you see similar, little we could able to see, understand here and get that effect here under section 30, where it says with the intent to defraud the creditor of limited liability or any other person. So it is not that intention is only to creditors of the LLP. No, if the intention to defraud any other person also, then your limited liability is lifted. So it becomes unlimited liability in case of fraud. So if you see and or for any fraudulent purpose, same language what is there in 447. And the liability of the limited liability and partner who acted with intent to defraud or for any fraudulent purpose shall be unlimited for all or any of the other liabilities. My God, it's similar like a partnership form where the partners are completely exposed in case of any liability without any limitation by means of limited liability. So similar way, they are completely. Here, one important thing, again, if you see the proviso, in case such act is carried out by a partner, a limited is liable, is to the same extent as a partner unless it is established, LLP, that such act was without the knowledge or authority of the LLP. So if you see partner as well as LLP. So it's very detailed way. Why I wanted to show this very importantly, there's a reason behind it. Here if you see subsection 2, here the amendment has been brought. That's why I wanted you to see this. Where any business is carried on with such intent as mentioned in subsection 1. Every person who was knowingly party carrying on the business shall be punishable with imprisonment, which is a term extended to 5 years today. My dear friends, why I want to explain to this with giving more importance, I could see that special court provision which talks about two category of the court. One, the category 1 is the imprisonment up to which could be heard up to 3 years. The other category is that imprisonment up to more than 3 years. Okay, session court, which we deem it as a session court. Okay, but though it is a special court for the purpose of Companies Act and for the purpose of LLP Act. Okay, now in the entire act, I could see most of the provision. I could see the maximum is 2 years imprisonment. Most of it. I was wondering why there is a second category of court which is the offence falling, which could be heard by the special court having an offence punishable more than 3 years. But this is only one section which I could see the entire LLP Act, which today says more than 3 years. My God. With this, if you see, the limitation also will go away. Please note that it's not that what are the limitation given under section 460 of the Criminal Procedure Code, where if the offence is punishable up to the imprisonment of 3 years, then the action should be taken within 3 years. Since today the provisions of 2 years has been extended or changed as a 5 years, the protection that are available under section 460 of Criminal Procedure Code and lifted now. That means offence committed by the LLP or partners, okay, if anything is committed and which is falling within the purview of section 30, and even after the period of 10 years also it could be, action could be taken and action could be initiated. The reason being the section, as I was referring, 460 of Criminal Procedure Code, which gives a limitation of 3 years, is being lifted. Since the imprisonment is going beyond 3 years, today it is 5 years. It's very important. So I thought I could share this information. It's very importantly, one should understand under the LLP Act Today, it's not a simple increase of 2 years to 5 years. It has got a lot of other impact also. To briefly touch upon the rule, there are 2 amendment rules. Probably I'll take another 2-3 minutes, I close it. First amendment rule is that notified on 11/2/2022, which is effective from 1st April 2022. And what are the first amendment rule? The amendment rule touches upon the postal orders and bank drafts has been removed, and name availability, and all this has been today has been deliberated by earlier speaker also on trademark and who should make an application, and trademark owner should make an application within the period of 3 years. All these changes have come. Same way when direction is given by regional, by digital director to change the name, and the LLP has to change the name. Similar provision has been included, has been brought under the provisions of Companies Act. Fortunately, when this provision has been given, and as a stakeholder, I had an opportunity to give my view whether how it can be brought it, and this particular time I gave my views also on this, how the situation could be addressed in changing the name, by whether the RD imposed to give the fresh name under the Act in case the orders of RD has not been followed. So fortunately has been few of my views also has been brought in. And here if you see the LLP, if they fail to change the name, ORDNC, that means the name followed by, our previous friend has explained in detailed way. Okay, the order of regional director not complied with, and along with the serial number and with the LLP number. Whatever the LLP number, the ordinary earlier than LLP, the same number followed by all this. So if you see, by seeing that, we can easily able to understand that the company is, because the idea is that why this has to come, because when the deliberation took place, MCA, after levying the penalty also, if they continue with the same name, what is the recourse available? That is the idea they brought it. Why they bringing this change, that we have to understand. So today we know that the name will be changed, the sin will be changed this way, or name will be changed this way. No, idea is that earlier before this change, there was only a penalty prescribed under the provision. With that penalty, the RD or MCA cannot make the LLP or company to listen to them, because they may pay the penalty, still continue to do the same thing. They cannot stop. They does not have a power to stop them under the provisions of the Companies Act. That's the reason under the Companies Act they thought of that something has to be brought in to make it public that this company is violating it and continuing it, so that further investment or any takeover, any kind of a participation by JV or any participation by stakeholder, they should be alerted that this company is violated the provision already of the vision. That's the idea. The idea of bringing that earlier, they were not having a power. By invoking the power, they brought these changes in the provision. Coming to the second amendment rule, as you know that these amendment rule already came into effective. Our friend has explained this little, but still I try to touch upon few things. All LLP forms have been made web-based, and completely all forms have been given in the notification, in the what are the amendment rule, in that they are given all the forms, and they, in fact, detailedly they are trying to cover all the details, entire details of a director's designated partner is captured, and the new LLP portal itself is launched. And so if you see that new form, Philip has been, it can be earlier only up to 2 DP was permitted under the form. Today, if you see that up to 5 DP was permitted, and along with that, earlier how in a SPICE form for a company they used to generate a certificate of incorporation along with the PAN and TAN. Similar way has been amended. The provisions of LLP has been amended, and the facility also has been extended in such a way that certificate of LLP, incorporating LLP, will be given along with the PAN and TAN. So similar thing what has been followed in the Companies Act has been today extended to the LLP also. And LLP under, as I was saying, CRP and liquidation. So there is a statement of insolvency. In case of a company, financial statement has to be filed under section 129. As you see, the financial statement has to be done and to be filed. And here statement of insolvency has to be filed. Whereas if you see that practically what is happening when the company get into the CRP or under liquidation, the RP or IRP is deprived or is not in a position legally to sign an accounts or make a filing. Though practically RPs are doing signing the financial statement and trying to file it, but still there is no legal backing what they were doing. Still even now Companies Act, there is no legal backing whether the RP or IP can sign a financial statement or annual return, which will be treated as equivalent to for the purpose of compliance under the provisions of Companies Act. But fortunately, the LLP Act has been amended that permitting, probably not under as a compulsion, they are permitted to sign as a IRP, RP, a liquidator, and to file the statement of insolvency as well as the annual return. These are the Companies Act provision of Section 90 and 164, which our earlier friend has clearly explained. I wanted to just throw only one point here. Section 90, which talks about the register of beneficial ownership. Okay, it only talks about SBA, significant beneficial owner. In fact, Companies Act, if you see Section 89, which talks about beneficial owner, giving a declaration by beneficial owner. Section 89 only defines what is beneficial ownership. Section 90 does not define. Section 90 only refers Section 89 for the purpose of deeming a particular transaction as a beneficial or a particular person as a beneficial ownership. Then he has to see the definition, the provision which is contemplated under Section 89. But I doubt here by making it Companies Act provision Section 90 applicable to the LLP, now I doubt in case of definition, what is deemed as a beneficial interest, which is available in Section 89 only, not in the 90. Then probably we have to wait and see whether Ministry clarifies this particular point. Though Ministry focuses on to understand who is SBO in the LLP. Okay, that's the idea. But here there is a linkage between 89 and 90 where 89 only gives a clarity of what is beneficial ownership. Okay, after reading the 89 only one, or after complying the provisions of 18 only, one can come within the purview of 90 to deem it as what is beneficial ownership. But now, with the help of only Section 90, can a person be deemed as a SBO? Is a question. We have to wait and see. Similarly, 164 and 165, disqualification and number of directorship, and 160 vacation, whatever exactly there in the Companies Act has been almost borrowed in the provisions of the, means the same provisions stand applicable to LLP. So they need not to bring it in the LLP Act. That's the idea. Because by invoking Section 67 under the LLP Act, the Ministry is notifying and saying 206 subsection 5 and 207, 252 and 439. And these are the provision which I was talking. Offences to be cognizable. Again, one more thing I wanted to discuss and close. I wanted to just give it to your knowledge, probably which I could come across. See, it says Section 439 offences to be non-cognizable. So already the offences to be non-cognizable made applicable by virtue of this notification, which has been made applicable. Okay, under the provisions for. So these sections have been made applicable 11th February 2022, means with effect from 1st April. Of course, everybody knows that all the provisions are stand applicable with effect from 1/4. But here this particular thing applicable from the date of the Gazette notification, 11th February 2022. Here already if you see Section 439, offences to be non-cognizable. So offences to be non-cognizable, if you see same 439 under the provisions of Companies Act, it makes it very clear what are the offences are coming. It only says that offences notwithstanding anything stated except the offence coming under Section 212. 212 is the clear this thing, notwithstanding anything stated in Criminal Procedure Code. It gives additional ground for the granting a bail to a person who is committing offence under Section 212. In addition to the, what are the elements that are required for granting the bail, Section 212 gives additional element to, additional conditions for granting the bail. So, except that, it says that notwithstanding anything stated in the Criminal Procedure Code, except the offences referred in 212, because it's clearly said that, shall be deemed to be non-cognizable. Okay. So that means other offences and all non-cognizable, and except the offence of section 212. But if you see, same thing, amendment by bringing section 67A. By 67A, 77A, no court other than the special court shall take cognizance of offence punishable under this act. Okay. So, rule made under say on complaint made by registrar or by an officer. But where we see the similar provision which is notified under so-called February notification which I referred, it gives a power not only the registrar, it gives a power to the partners also to deem it as a on giving a complaint by not only by the registrar and also by the partner, because it amends to that extent, it amends the provisions of the section 439. See, mean to make it applicable to the LLP. But whereas section 439 only says it is applicable. That's why they brought an amendment saying that in addition to the registrar, the same provision has been made applicable. Even no court shall. Yes, just a moment. No court shall take cognizance under the act alleged to have been committed. Except on a complaint by registrar or partner of LLP. Okay. So here partner word is there, whereas in the provisions of complaint that is missing. Anyway, Madam, I'm done with the session. Sir, you can carry on. I think already our participants become restless. They start talking. I'm done with my sessions. Any question or answers you can ask me. Probably.
Yes, thanks, CS Dr. S. and CS Manoj Mathia ji also. And both the learned speakers has explained these LP Amendment Acts in so detailed and so transparent manner that I have not received a single question from the participants, from our members. Let me congratulate to both of you that, and let me congratulate myself also that we have not received a single question from our members. For your transparent description, for your detailed answers, and all the LP Amendment Act in a capsule form for the members in a short span of time. My thanks to both the speakers for sparing your valuable time, for sparing your ideas, for giving your insight thoughts to the LP Amendment Act. Now I formally propose a hearty vote of thanks on behalf of me, Chairman of the Practicing Company Secretaries Committee of ICSI, and on behalf of ICSI, to both the speaker, both the learned speakers for their sparing time to us. I am sure that all the participants, all the members has learned it and has a immense benefit for all. Now, I would like to request team ICSI to please show Shahid Ke Beti certificates to CS Manoj Mathia ji as a local law, as a token of our respect to Manoj Mathia ji, please, sir. Now, I would like to request team ICSI to please display Shahid Ke Beti certificate to our learned speaker, CS Dr. S. Dhanpala, sir.
Thank you, sir. Thanks a lot.
Now my heartfelt thanks to both the speaker once again, sir, and hope whenever we need you, we will get it again, sir. Thank you very much. Thanks to all. Thanks to participants, and thanks to team ICSI also. Thank you.
Thank you all for your patient listening.